the first thing I want to do tonight is make sure that everyone knows how to find some very pertinent information that is on our village website. So we're going to take just a few minutes to navigate through the website, and Bill Kress, our information officer, is going to help me with that. And once we go through that, we'll stop and take questions on the website, and then we'll move on to the next topic, take questions on that, and move right on through the agenda. So to start with, I'd like to introduce you to some people that are here tonight. We have our mayor, Mayor Stanzik. If you'd stand, please. And are there any other council members here tonight? Seeing none, let me go on over here to our village manager, Mr. Ron Williams. If you'd stand, say hello. Megan Alexander, our village clerk. And our new village attorney, Mr. Dexter Clayton. All of you in this audience are distinguished guests, and I'd really like to call out each of your names. You're all very dear to me, and I'm very happy to see you here tonight. Let's get right to it. We did have a handout on navigating the village website. Is there anyone who doesn't have that handout? We have a few more up here. Let me get those to you before we start. Thank you, Mayor. Thank you. The clerk has reminded me that it would probably be a good idea to read the decorum statement, so please bear with us as she does that. Thank you.
Any person making impertinent or slanderous remarks or who becomes boisterous while addressing the council may be suffered for further appearance before the council by the mayor, unless permitted to continue or again address the council, granted by a majority vote of the council. Applauding speakers shall be discouraged. Heckling or verbal outbursts in support or opposition to a speaker or his or her remarks shall be prohibited. No signs or placards are allowed in a council meeting. Persons exiting the council meeting shall do so quietly. All cellular telephones and beepers are to be silenced during the meeting.
Thank you. All right, we're going to start out on the home page of the village website, which you will see on the monitors. And I'm going to turn this over to Bill Kress, our information officer, and we'll sort of do this together, but he's going to start.
Thank you, Councilwoman. Yeah, I'm pleased to be here tonight. Bill Kress, the communications manager and public information officer for the village. I live, eat, and breathe these communications vehicles. I don't know if you all participate in the e-currents and the Facebook and the village website, but the mothership, if you will, is the website. So everything that we put out in terms of Facebook and e-currents, as I mentioned, it all comes back. It's all geared to come back to the website. And just for a couple of geeky points, I thought you might be interested to know that we had in the last month 38,000 page views on our website, which it just astounds me. 27,000 are unique page views. And the top 10 pages visited are kind of a reflection of this community. People are most interested in Coral Reef Park is number 3, behind the home page, which you would think would be number 1. And the list of departments is number 2. But human resources is in the top 10. Buildings, because I believe people are looking for permitting information. Police, parks in general. Palmetto Bay Park is a top page that's hit. So that's what comprises the top 10 pages that people visit when they come to the website. And when you come to the website, only in the last week did we change out these pictures because it's National Public Works Week. So we've done a little homage to some of the public works programs in the village. So getting to the website and why you invited me here today was first and foremost to show you a relatively new feature, which is how to reach the council in a group. And we put that in perhaps the most prominent spot on the homepage, which you can see, it says council email, and you can click that, and it will take you, under normal circumstances, right to what would be a setup template on your computer. It would take you to your, whatever your default email is, and it would give an email address. So that's fairly simple. Or you can go to each of the council members' page and get their individual email. But this is supposed to be just an easy and convenient way for you to communicate directly with all of the council members in one click. Another important component of the homepage is the village headlines, which it's my intent to change this out almost daily. It's fairly important to keep this content fresh, keep people coming back, and this will always be the top news and events that are going on in the village. And then those top news and events will then kind of rotate down into news and events, which ultimately becomes a history of the news and information and events in the village. But going back up, I wanted to point out a relatively new feature again over here called Council News. You can see me swirling. What we wanted to achieve here was to offer a spot for individual council member communications, events, news, and happening. So you can see it rotates, and if you want to hit, we'll wait for the councilwoman to come up. What you'll see here is what their most current activity is, what their most current event. And here we have tonight's event for Councilwoman Lindsay. And then it takes us over to her page and information about her specific town hall tonight or your bike to work.
Exactly, and one of the things that I would like to point out to you is that I will be doing a PowerPoint presentation tonight. That entire presentation and more detail will be available to all of you on the website by clicking on my picture. So if you feel like we've gone over something tonight that was not completely clear or you'd like to read it again, it's all there and it's there now.
Then we have just the general council news area. Village Council, and it tells you a little bit about the function of the council, and then it lists each of the council members. You can visit their page as well as get their individual email address. Another spot for you is you have it down here as your government. Here again, you can find the village council contact information on each of them on their own page. And then the village clerk maintains a number of pages that would be public meetings, the elections page, which is Megan Alexander serves as the election officer of the village.
And Mr. President, I'm going to interrupt you. That is a very important page to all of us this year because we do have an election in November. If you go to the elections section of the village clerk's page, you will find all of the offices that are, going to be on your ballot this year. You will find the candidates who are running, and you will also find their campaign finance reports, which will tell you a lot about who is supporting those candidates. All valuable information that you as voters may want to look at. We also have, if I can take the spotlight here, Mr. President, on that same page we have under the village clerk, the last item there is your village charter. That is like your constitution, and that is a very important document. Some of you may have seen that before. It is available for you anytime. Moving on down the right-hand column, under your government, we have services, and we have in that column our code of ordinances. Now, Mr. President and I have talked about perhaps putting that under information, but at the moment it's under services. And this is where you can go to find any ordinance which is part of the municipal code that governs all of us. We had a meeting a couple weeks ago on May 5th where a lot of us were talking about Section 30-110. You could go right to this spot on the village website, and in the search box at the top, once you get to the page on the Code of Ordinances, right up there at the very top, you can actually type in SEC for Section 30-110, and it's all there. That is your Palmetto Bay Code. If anyone's interested in finding other municipal codes, whether it be the county or another city, I'll be happy to go into that with you on an individual basis. We also have listed there in that same column under services, we have the Muni Code. The Muni Code and the Code of Ordinances are the same thing, and both will take you to the same place. Moving on down, we have a section for notices. This is all on the right-hand side. We're going to go back to the home page so that you all can see that these are on the home page. Okay, we're back to the home page and moving down the right-hand column where there are just so many things that you might want to look at from time to time. We're going down to the last box on the right-hand side titled Information. And there are many things here, and certainly this meeting is not just about the website, so I'm just going to call your attention to a couple of things in that list. One of them, which has become very important to many people, is litigation. If you go down there where Bill has the arrow and click on litigation, it will take you to the page you see here. This page has a lot of documents that I'm going to be referring to tonight. Everything from my PowerPoint, with the exception of what our village attorney is providing, is available for you to read on the village website. It's there now, it's been there, and we just want to make sure you know where to go to find out all of this information. If you look at the handout that I've given you, you will see some things that I have listed there under litigation. This is actually all on Palmer Trinity at this point. That first item on the handout that I gave you is August 29th, 2012. That is the resolution number 2012-64. That is the resolution that was passed 2 years ago practically, and that resolution contains all of what you need to know about the development order that was written for Palmer Trinity. Moving on down that list, you have the Fifth Amended Complaint. That is the lawsuit from 2008, which we'll be talking about more later. June 12, 2013, an order to dismiss the Fifth Amended Complaint. The reason the motion to dismiss the fifth is in parentheses is because that's not what you're going to see on the village website, but I wanted you to know that that's what that was. And moving on down, you'll see the next section is video. Now, every one of our town hall meetings has not been videotaped. We have some folks here tonight who are doing their own videos, and I think Mr. Feldman in the back is going to make his video available to you, and I will let you know how that will work a little bit later on. But our council meetings, our COW meetings, which are Committee of the Whole meetings, and also our zoning meetings are all on the website. They're videotaped. You can go to the section, moving on down on the right-hand side of the home page, you can get to the videos. It says video-public meeting. And there, if you click on that, you will go to the page that Bill had up a moment ago, which is this one. And if you scroll on down, you will see archived videos. You can continue with the arrow over there on the right-hand side, and you can go on down as, as far as possible. There will be more that come up there. We go back to October 2011. That's when we started. You'll also find the agendas for those meetings there as well. And so you have a lot of information available. I pointed out several videos here that might be of interest to you. You can check those out. If you have any questions on those, I certainly will be happy to answer them. But what we're trying to point out here tonight is that we have an information officer. You have a different title, I think now. What is your title? Communications Director. And he's working very hard to make sure every one of you knows everything you need to know about what's going on with your government, whether it's the code, whether it's litigation, whether it's public meetings, whether it's an archived video. It's all there for you. So the next time someone tells you that you're misinformed, you know where to go to get straightened out. And like I said, there's no reason for anybody to say, I don't know what's going on in Palmetto Bay, because you have it all here, and Mr. Kress has done an outstanding job of providing all of that for you. I think the manager would like to upgrade our website a little bit, and we were talking about that as well, perhaps bringing in some drop-down menus and making this a little bit more user-friendly. One more thing, and then I'll open this up to questions on the website. On that home page, there is a search box. So if you are looking for something, try that. If it doesn't work, keep looking, because this is a work in progress. And we certainly appreciate any feedback as to you're finding out something isn't working, but don't be discouraged if you can't find something. Try a different way. There are multiple ways to find information on the website. Okay, shall we take some questions from the audience on that? Yes.
Sorry. We can't sit in here, we're not going to be able to sit, so we're sitting out there, but it's so loud that I can't even talk to my husband next to me. Is there a way to
I'll
turn it
run
down?
the control room in just a minute to talk.
Okay, thank you. Thank you.
Okay, Sandra, how many people are out there?
Only, I think, 4.
Well, there are seats right up here, so. There's another seat on the front row over here. Come on.
Could I just jump in while we're waiting for a question? You know, there's about 200 eyeballs in this room right now. I would really appreciate it if you find a link or any information incorrect or outdated. Please feel free to give me a call. We want to make sure the website is always kept up to date as best as possible. Thank you.
Okay, Sandra, we have seats for guest of honor up here. Come on up. No. And maybe we can talk some of you into running for office. You might like the chair. Okay, does anyone have any questions on the village website before we move on to other topics? Yes, sir.
I just changed alarm company, and they gave me the identification number for the alarm company, and it's an ADT number. We got all sorts of ADT numbers on your website. However, this particular ADT number is not on your website. Okay.
Well, thank you, and I'll draw the attention of the finance department, which oversees that program, to your question. I'll get your name and number in a moment.
Sure.
We'll give you a call.
Okay.
Thank you.
Is there anybody else who'd like to ask a question on the village website? How many of you are using the website? Okay, next time we ask, I want to see more hands now. All right, well, let's move on then. Thank you, Mr. Kress. I appreciate it very much. What we're going to do now is, as I said, we're going to go through the topics. And the next topic that we're going to get into is the Palmer Trinity litigation. What I'm going to try to do here is bring you up to date, but in order to give you a clear understanding of where we are, we have to go back to the beginning. So we're going to do that, and I do have a PowerPoint. All of this information information, as we said a few moments ago, is available on the village website. All you have to do is click on my picture and go to the town hall. Thank you. Okay, this may be a little bit hard to read. I do not intend to read the whole thing. I'm going to hit on some highlights, and then, as I said, it's available to you on the village website if you would like to read it in more detail. All of what you see in this slide was written by our former village attorney and is available under the litigation topic on that homepage. Under Village Counter Offer, August 14th, 2013. She put the history of the cases there. I started in May 2008 with this, but just to give you one little step back, when we incorporated in 2002, we had a part-time zoning director, and we were sending our applications to the county. So when the Palmer Trinity application first came about, the county was handling it. In 2008, it came to the village. We had 3 meetings in 2008. Some of you may have been there at Southwood. We had one in February, one the end of April, and another in May. In May of 2008, the Palmetto Bay Village Council denied the Palmer Trinity zoning change request. In May of that year, Palmer Trinity appealed that decision to the 11th Circuit Court, the Appellate Division. This decision that the Appellate Court made in February 2009 was in the village's favor. Palmer Trinity asked for a rehearing, and in March 2009, their rehearing was denied. They based the rehearing on a case that the 3rd District Court of Appeals had recently heard, which was a case called Richard Rhodes versus Miami-Dade County. So the council denied the zoning change request in 2008. It went to the 11th Circuit Court Appellate Division. The court upheld the council's decision. Palmer asked for a rehearing, and the court said no. So Palmer Trinity appealed to the 3rd District Court. Now, the 3rd District Court had recently ruled on a case, the one I just mentioned, Richard Rhodes versus Miami-Dade County. And that was the case that the 3rd DCA used to overturn the lower court's decision. And Palmer Trinity then was granted the zoning change. That took from May 2008 till April 2010. Now you have to understand, the village was not dragging its feet. The court upheld what the village did, and finally, in the appeal to the 3rd DCA, it was overturned. So that's the first part of this. In April and May of 2010, the village held public hearings. The village changed the zoning to the zoning that they asked for, and all of this is on the website if you need more detail. And the village approved the site plan with conditions and 900 students. To make a long story short here, this went back and forth with the courts. Palmer Trinity appealed the decision. They appealed 2 conditions, the condition on the 900 students and the condition of the 30-year restriction. Those were the only things that were appealed. The court found in Palmer Trinity's favor, and I must say, and rightly so. In order for the village to have prevailed on the 900 count, there would have had to have been what we call substantial competent evidence. There wasn't any. So those of us who are now in village government have a valuable lesson to learn here. you don't make a decision in a zoning hearing without competent, substantial evidence, and that has to come from experts. And so this is a very important lesson for all of us to learn. Well, the court made a ruling and said, you must strike the 900, quash the 900, I think was the wording, and the 30-year provision, and do nothing else. And our village attorney brought it back to us and we said, well, what does that mean, do nothing else? When we strike the 900 and we strike the 30 years and we do nothing else, well, the resolution said that the 1150 was denied. So that left only 600. Now, I'm going to direct you to the litigation page as I did earlier. It's all there. You can read it in detail. I'm not here to bring all of this up again in any more detail than that, but if any of you want to talk to me about it, you can. Long story short, and remember this is now August 2012, if you go down to the last part here, the Village Council approved the Palmer Trinity site plan and the enrollment expansion to 1150, and that gave Palmer Trinity the green light to begin their development. The resolution is number 2012-64. It is on the litigation section of the village website. Now, before I go any further, does anyone want to ask a question about anything I've said? Yes?
Who decided the 900 students?
The 900 students was voted on by the council, and that is all part of the documents. The 3 individuals who voted for that were Jean Flynn, Shelley Stanzik, and Brian Pariser. Now, the thing that's interesting about that, and Mr. Singer, I want to add something because that was a good question, but the most important question is who voted for the resolution? When you said who voted for the 900, there was an intermediate vote, okay? Because that was an amendment to the resolution. So there were 3 people who voted to amend the resolution, but there were 3 people who voted for the resolution in its entirety. And I will say this, Jean Flynn and Shelley Stanzik did not vote for that resolution. So they may have voted for the 900, but they didn't vote for the whole package. So if you want to see who voted for it, if you want to ask me about that, I can tell you, but otherwise we'll move on. Are you good? Okay, great. All right, so let's move on. This is a very important segment of all of this because this is the appeal section of the council's decisions. But at the same time that the appeals were going on, Palmer Trinity filed a lawsuit. The first lawsuit was filed in 2008. That was filed with, it's called the 2008 original action, and that was filed in the 11th Circuit Court. Now, remember that the decision that this was based on was the zoning change only. Palmer Trinity had requested on that 33-acre parcel that the zoning be changed. The zoning had been half agricultural and half 5-acre estate. And they wanted the whole thing to be half-acre estates. Half-acre estates have smaller setbacks. So with the agricultural zoning, they could have built the entire school. They could have done the footprint of the buildings. But they wanted to do a little bit more, and in order to do that, they had to change the zoning. So this 2008 lawsuit is about that issue, changing the zoning. Not about the zoning change itself, but about civil rights and due process and ex parte communications. And in a very short order, I'm going to invite our village attorney to come up, who's going to tell you much more about that. But what I want you to know is when Palmer Trinity filed that appeal, they didn't like the council's decision, not to change the zoning, they also filed at pretty much the same time this 2008 original action in the 11th Circuit Court. And this time they were requesting damages. You don't get damages in the appeal process, you just get a decision. Here they're requesting damages. Now, this particular lawsuit has been going on a long time. They amended it in 2010 in August. They amended it again in March 2011, in May 2011 again, in October 2011 again, and in October of 2012, they came up with a 5th amended complaint. That complaint has 14 counts in it. 11 of those counts are against the Village of Palmetto Bay. The other 3 counts are against residents and CCOCR. The lawsuits, that was the 2008 original action. After the hearing where they got their whole site plan, they got their zoning, they got all the buildings, they got all the ball fields, but they didn't get the number of students that they wanted, so they appealed again and they filed another lawsuit. This one's called the 2010 original action, and this one alleges that some village ordinances are unconstitutional and they're seeking declaratory and injunctive relief. That's not a damage claim as I understand it. That was amended in July of 2010 and August of 2010. Now, let's go back to the lawsuit which we're calling the 2008 original action. The 5th amended complaint as it's known. Again, it's on your village website. All you have to do is, does anybody know? How do you find this? This is a quiz. Oh, come on. I'm going to get Bill Prescott over here. Okay. Who can tell me how to get to the village website for this section? Liz.
You get on your computer, you click on, you type in Village of Palmetto Bay, it should come up, and then you go under litigation. You can find it on the drop-down list.
Absolutely perfect answer. Thank you. Now, there you will find this 5th amended complaint. You will also find something there called a motion to dismiss the 5th amended complaint, written by the attorney for the village, Jeff Hockman, who is assigned to us from our insurance company. That's through the League of Cities, and we'll talk more about that shortly. Now, in addition to that, you will find the village's answer to the 5th amended complaint. So if you're wondering what the village has to say about any of these allegations, it's all there, all right? And as I said, we'll get into that in more detail shortly. Now, in October of 2012, as I said, the 5th amended complaint had 14 counts. Counts 11, 12, and 13 are not against the Village of Palmetto Bay. Counts 3, 4, and 12 were dismissed by the court in June of 2013. Now, I'm going to turn this over to our esteemed attorney, but before I do that, do any of you have any questions about what I've had to say? Mr. Layton, you're on.
With respect to the Palmer Trinity matters, they are unlike a lot of legal issues which are more complicated than they may first appear. The Palmer Trinity issues are actually simpler than they first appear because of the point at which you are now. The land use disputes were finally determined in 2012. That is to say, what Palmer Trinity was entitled to do as a school. Those disputes that sometimes would be characterized as Palmer Trinity vindicating their rights by court orders and the village conforming, on a side, number of students and so forth. But those were finalized in 2012. Any land use issue that currently exists is a new application to be considered on the merits, may be granted or not granted, like lights were unable to be granted as long as the code prohibited them and so forth. But land use disputes are over with. The new applications are just new applications to be considered on their merits, and Palmer Trinity has one of those community meetings coming up. The litigation, which is often described as part of the Palmer Trinity disputes, are practically part of them. The litigation arose from the delay that Palmer Trinity alleges were involved in the land use disputes. But that litigation is not a land use dispute. It's an argument over whether a certain delay constitutes violation of due process and whether it's compensable by monetary damages. A lot of them are federal claims, as a lot of lawyers do. They'll throw out the 14th Amendment and this amendment and that amendment and so forth, which are important amendments as citizens, but it's common in the law to allege violations of the 14th Amendment in all kinds of different circumstances. So let's deal with those. What I say here, and this is posted or will be posted on the website as well. What we have here is simply a statement of what I just said, that the current litigation with Palmer Trinity is civil rights litigation. It's an argument that they make that they were deprived of due process in various ways during the land use disputes, and that they had to vindicate their rights through the courts. And once those rights were vindicated as they saw them in 2012, they maintained that the delay that came about, not that the 2012 decisions are improper or being challenged, or that there's anything wrong with the 2012 decisions. They could go forward and build based on their site plan and their current development agreement, 2012. But their argument is that what they had to do to get to 2012 constituted delay that should be compensated by money. The point is that these are not litigation that can be settled by giving them a land use utilization, different land use. Consider it this way. If the code prohibits something and somebody has another lawsuit that says we want 10 million, but we'll take 200,000 if you change the code, no public agency is able to sell its code, to sell its public process that way. Not that were the code changed, it would be that. It's simply that if the code is changed for any reason, it has to be village-wide and done on the merits. And with respect to lighting, there's some communities have lighting, some communities don't. It's a matter of public policy. This community right now has a prohibition on the lighting in the residential areas, which Mr. Hoffman, who represents this village, under your insurance with the Florida League of Municipalities or whatever that entity is called, he and I are both confident that it's not unconstitutional to not allow a school to have lights. Actually, it's not unconstitutional to allow them to have lights either. It's a matter of public policy that's determined in the democratic process. So, not only does the litigation is not over land use matters, the judge to rule entirely in Palmer Trinity's favor, which I hasten to add that Mr. Hoffman does not believe will happen, nor do I. He's authorized me to say he does not believe that Palmer Trinity will prevail, and I do not believe they will either. However, were they to prevail, it would be money. The judge could not order lights and could not order site plan changes because the litigation is over money, and the judge has no authority to order land use changes in unrelated litigation. Consider that litigation to be like an auto accident. Maybe there's a lot of money at stake, maybe there isn't, but you can't compensate somebody for the auto accident by but and the details, the actual numbers may be unimportant, but the general concepts are here. Of the 14 counts, 5 of them, or 4 of them, I believe you said 3, but the numbers are, 4 of them do not involve the village. 1 of them that involved the village is dismissed, so 5 of the counts don't matter. There are either 3 or 4 or 5 counts that allege federal civil rights or constitutional violations. I say 3 or 4 or 5 because you can read certain of the counts and they seem to, as the old people would say, or Matt would say, they seem to sound in state law. However, they'll end up with a conclusion that everything we just said violates the U.S. Constitution also. So, if it violated state law and it violated the state constitution, yeah, it probably violated the U.S. Constitution as well. If, I just say if. So, there are 5 counts that, in one way or another, claim this would be a violation of U.S. constitutional law. Now, why does it make a difference that there are federal counts and so-called state counts? Because the village, like almost all municipalities in Florida, is insured against federal claims, which may sound strange. Why would you insure against federal claims and not state claims? The reason is that you have state-established sovereign immunity with regard to state claims. With regard to fundamental U.S. constitutional claims, that's the 14th Amendment, you know, it's the post-Civil War amendments, where Congress found it necessary to override state sovereign immunity, you know, during Reconstruction and so forth. The history is unimportant, except to recognize that the federal government's overriding state and local sovereign immunity was an important element in enforcing civil rights, you know, and getting rid of the black codes and so forth like that. So the point is that your sovereign immunity does not protect you against federal civil rights violations. So all municipalities purchase insurance against that, which pays 2 different elements, of course: the cost of defending the lawsuit, legal fees, and the cost of liability. Your liability policy is $5 million. You've read this or heard this before, but I've talked to your insurance people to make sure and looked at the policy. It's $5 million per occurrence, which means actually if something happened in 2008, which neither Hoffman nor I believe is the case, but it's alleged in 2008 that resulted in liability, that would be 1 occurrence. It might violate 3 or 4 provisions, state constitution, federal constitution, this, that, or the other, whatnot. But it would be 1 set of damages, and you'd be covered for that. And then if there was something different happened in 2012, that's a different occurrence. Your policy is not $5 million total, it's $5 million per occurrence, which is actually a nice policy. That's why the federal claims are important. Now, I'll mention later that federal constitutional principles generally do not provide monetary relief because of delay in land use proceedings in the state. The U.S. Constitution, the Supreme Court views the proper remedy for a denial of a land use matter as being an appeal. And if you win on appeal and the court system gives you a remedy, you've got your remedy. Just in case you're wondering why you haven't read in the newspapers that every time somebody wins a land use decision on appeal, they don't end up with a due process claim, arguing that between the time they were denied and the time they won on appeal, they've been denied due process. The general view is your due process is vindicated in court, and if you don't like the length of time it takes the courts to decide it, do something about the courts. But you're getting your due process as long as you're being granted your right to appeal and your right of access to court and so forth. But anyway, that's just a comment about the viability or lack of viability of the constitutional claims. The next issue is there are 2 state claims that do not involve money. One of the claims is that the state statute that explicitly permits communications to the governing agency in a quasi-judicial proceeding as long as the government officials reveal the communications and the statutes reviewed. One argument, and most municipalities and counties rely on that in Florida, one argument is that that is unconstitutional. And were that the case, there'd be hundreds of municipalities affected by it. And it would only change that law as well. We do not believe that good faith reliance on a state statute should not result in monetary damages. As a matter of fact, you're likely to be more likely to be expected to rely on a state statute than to look at a state statute and say, fine, on the state legislature, we don't care what they say, we're going to do it differently. Meaning, relying on a state statute is reliance on good faith. It's hard to argue. That's kind of akin to what Councilwoman Lindsay said about the fact that, the reason she emphasized it, by the way, that when the council denied the zoning, the first appellate division upheld the council's action, and then the 3rd District Court of Appeal reversed it. The significance of that is that a judicial panel found the municipality's, the village's action to be reasonable. So in order to claim that there was a gross violation of fundamental rights, you really should be suing those judges who, at the first level of appeal, said the village had acted properly. As a matter of fact, they would actually be the cause of the delay between their decision and the 3rd District Court of Appeal, but you can't sue the judge, of course. And that's mainly the reason you can't sue the municipality either for that kind of delay. Now, a lot of you have been caught in delays in the court system, and they're very frustrating, but the remedy is to get the court system to act a little faster. Now, the other two, there are 2 claims, and when I said there were 5 federals, 3 of which were clearly federal claims and 2 of which had federal language tacked onto them. That means that there are 2 state claims, purely state claims, or 4 if you decide that the other 2 that tack on that last bit of, oh, and by the way, remember the 14th Amendment, along with the 14th Amendment kind of language that makes it a federal claim. If they were not federal claims, then you'd have 4 state claims that conceivably could produce monetary damages. Now, generally, Florida has also not recognized delay in land use decisions that are properly going through the court as being a violation of due process. But if it did, then these could provide monetary damages. The complaint cites a bunch of language like deviation from the fundamental requirements of law and so forth, and repeats that and puts it in bold and so on like that. Not a very professional way of writing a complaint. But I would point out that those are simply the legal standards that whenever the 3rd District reverses on a basis of a petition for certiorari, that exact language will appear, that there was a deviation from the fundamental requirements of law and so forth. And the reason that's important is because if you were to read the complaint and equate something like a deviation from the fundamental requirements of law, initially sounding like it's a due process violation, that would be incorrect. Or else every time the 3rd District Court of Appeal granted a writ of certiorari because of a deviation from the fundamental requirements of law, you'd end up with a damage lawsuit for a violation of due process, and that is not the case. The state's standards of review, and when they find that they want to reverse a lower court, the language they use does not automatically, or almost never, itself establishes a violation of due process. In fact, it's often argued correctly that the fact that you're in court and are able to get an appellate court to make that statement in your favor actually proves that you have been given due process. You've been given your day in court. You won or lost below, you won or lost higher up. That's what due process is about. It's not outcomes. It's that you're given a chance for a hearing. Now, the other thing about the state claims, the reason the classification is important, is with sovereign immunity, neither this municipality nor most municipalities or counties in Florida bother to buy insurance for state claims. Why? Because you either have absolute sovereign immunity, or the state legislature, out of a sense of fairness, has waived your sovereign immunity, and the counties and the states, only up to $100,000, but has waived it for personal injury torts and for property damage torts. What is that commonly? One of your village vehicles runs over somebody and causes personal injury. If the state legislature did not waive sovereign immunity, that injured person would have no remedy whatsoever, which seems rather unfair. So the state legislature has said, in those cases, personal injury torts and personal and property damage torts being an injury to another, based on a violation of the duty of due care. That's the kind of first-year law school statement of it. That you can go to court, and if you get a judgment, you can collect it from the village or the government up to $100,000. Now, if you get a $2, $3, $4 million judgment, you get $100,000. You are allowed to go to the state legislature and get a legislator to file what's called a claims bill, and the state legislature looks at that judgment for $4 million to see if the legislature wants to waive sovereign immunity to a greater amount. And sometimes they do, often they don't. When they do waive the sovereign immunity and tell the local entity to pay the bill, they almost never allow the high contingent fees that are in there. They put a condition on contingent fees can only be 10 or 15%, not 33%. And they usually deny punitive damages. I'm just saying to you from experientially what happens. However, that's actually unimportant as well, because your policy covers you if the legislature passes a claims bill, which is mostly we're very careful not to say something certain. But you know, I've heard that the earth revolves around the sun, and I'm about as certain that the legislature wouldn't pass a claims bill in this case as I am that the earth revolves around the sun. So that's really not a risk. But the point is, it doesn't matter because you're covered. By the way, the reason you get that in your policy is because the insurance company doesn't think the legislature is going to pass a claims bill either, okay, which is why you don't pay a high premium for that. But the point is that were you to lose certain state claims, there would be either no damages. You might, if you're a budding law student, say, well, actually, if you have sovereign immunity, you shouldn't have to defend the case, but sometimes whether you do or do not have sovereign immunity depends partly on the facts of the case. So, but in certain instances, you don't even get the case tried because it's clear you have sovereign immunity. But you'd either be owed nothing or you'd owe $100,000. And you would, if there was only the state claim, then you'd have to pay your own attorney's fees. But your policy does provide that if the league is defending you for federal claims, any federal claims, then any of these trail along state claims get defended under the policy as well. Now, it is true that if all of the federal claims disappeared, then you would be defending the state claims, not so much worried about liability, but you would be paying attorney's fees if there were no federal claims and there were only state claims. It is practically very difficult to see how a set of facts that are just alleged and then you throw in there that violates the state constitution and it violates the federal constitution and it violates like the UN Charter, if you talk a lot about that. It's very hard to see how the federal claims would disappear and the state claims would not. You can probably think of one way. Ms. Lindsay's a former teacher, so she did that to you, right, like my wife does. Just ask the question. She couldn't resist it from the podium. But I would ask you, there's one way that the federal claims could disappear and the state claims remain, and that is if the plaintiff voluntarily dismissed the federal claims and not the state claims. But the federal claims are the ones that don't have sovereign immunity, so they're not going to voluntarily dismiss those just to make you pay attorney's fees. Well, having said that, maybe I'm wrong, but the point is that if they voluntarily dismiss those just to leave you with state claims, that's a significant victory on your part. I wouldn't worry about that. That strategy, that's like the Indianapolis last night, not doing fouls, putting up in the last 30 seconds. Okay. I think I've said that, not insurance statement. Okay, here's a list of these counts. The only reason you want to take this off the website, if you were so inclined, is to see that they really are quite repetitive. An argument that ex parte communications are unconstitutional is a little bit different than saying if they were constitutional because they're revealed, then there was a violation because they were purposefully not revealed. Hoffman and I, as lawyers, believe our clients. We have no reason to believe there were ex partes purposely not revealed. What can I say about that? It's just kind of thrown in there. You see, number 5 is a true federal claim that it's an equal protection violation, state claim as well, to treat public schools differently from private schools. The only thing about that is that Hoffman and I have never found that to be the case. Public schools and private schools are almost always treated differently in zoning laws. And were they to win that, it would have national, I guess not international, but national significance, because there's probably no code nationally that doesn't have some form of distinction there. The Citizens Bill of Rights is not a monetary claim. Public records, probably the only place that that you're not insured is like this public records claim, because statutorily your sovereign immunity has been waived. That's where a citizen has a right to get a public record, and if the entity denies the public record, then they can sue and collect attorney's fees for the need to sue for the public records. So theoretically, there's an attorney's fees claim here, but I don't believe you can just bury a public records claim in a big lawsuit and then not diligently pursue the public records claim and then try to sweep every legal fee related to everything else into a so-called public records claim. My experience is not important, except I chaired that committee once in the legislature and have successfully sued many times, and I cannot envision why, if they have a public records claim, why they haven't pushed it, or tried to get the public record or whatever. That's an independent claim. I think it's kind of showboat kind of stuff, in the complaint. Of course, I don't have personal knowledge as to whether there's a public record that was denied or not, but if they think they do, they should have pursued it, not just bury it in some complaint here. Then Section 1983 is a jurisdictional statute, a federal jurisdictional statute that gives the federal courts jurisdiction to hear civil rights violations. It's one of those Civil War efforts, so it doesn't really add any new claims. It's still due process. And by the way, what would the due process claims be? That it was wrong to deny them zoning? Well, an appellate court first upheld that. You were right, so that one's not really very strong. Then there's you were wrong to put a 30-year restriction on and wrong to do 900, but that was corrected by a judicial decision, as I've said. Usually your due process is deemed to be a government mistreats you, your due process is to get it corrected. That was, from the viewpoint of the plaintiff, that was corrected, so you don't really see that. But that's where those claims would be. Abuse of process. Technically speaking, that's a really silly count. That's kind of a legal term, silly. Abuse of process, the way it's pled is it's just constitutional claims again. It's the duplication of the earlier count. A real abuse of process is when the process means service of process. You suing somebody improperly or using judicial process improperly. There's nothing new there. Conspiracy. It's pled so that you don't know what they're conspiring to do. So it's either federal, state, or, as I said, something else, but it's not new. Whatever the operational facts are, claimed to be 600, 900, 1150. Conspiracy is the same thing. And then not village. Of course, it all depends on what you see depends on where you sit. If you're one of the not village people, that's important to you. You know, one of the defendants there, I'm not trying to diminish that, but it ain't, you know, it isn't our job, it's somebody else who's been sued. But they have all of the same offenses. And the temporary injunction they're not pursuing, but if they did, it's not monetary anyway. Okay, a couple of closing comments. On the substantive law, these claims have generally not been recognized as providing monetary relief. Your relief for a land use decision of the government is a proper appeal, and you're vindicated if you win the appeal. And that's what they had. You know about the insurance coverage. You know about sovereign immunity. I mentioned that. Okay. Damages. So let me say this. It has been asked several times, so I should say. The one set of operative facts, if found to violate some legal principle and give rise to damages, would be the same set of facts if it violated some other law doesn't give rise to damages times 2. Okay? If something the village did violated 3 laws, you don't get 3 times the damages. You just get one damage. That's important for your per occurrence part of your insurance policy, right? Because if you get 5 claims against you, but they're all the same thing, the 600, 900, 1150, you know, just to identify it by title. If that violated 5 things, they get damages if they qualify one time. You have a question?
I just wanted to ask you which kind of damages
Okay, so, you mean how okay, let's go to that. The interesting thing about damages is that, again, to take it in sequence, not to be too repetitive, we don't believe the substantive law recognizes monetary damages. If it did recognize monetary damages, it would only recognize one damage for if something happened in 2010 and violated 2 different laws, you'd get damages from 2010 forward. Now, notice this. The 2008 complaint is very difficult to see the village doing anything wrong because the appellate panel said you were right. So they've got to be wrong too. I often tell law students, you know, if you can identify the legal issue and apply it cogently, I really don't care what outcome you get, because look, we're reading cases that are 4-3 in the state Supreme Court and 5-4 in the U.S. Supreme Court. And, you know, theoretically, they all pass law school, the 5 and the 4. So I don't see how the village can be liable when the appellate panel thought you were not. The next panel did, but that's not unusual. We often count a 5-4 Supreme Court decision, and then we look on the lower panel, and it was 0-3, which meant if you count federal judges, there were 5 one way and 8 the other way. And then you look at the first judge was that way, it's 5-9. Now, why did the 5 win? Because they're like the Supreme Court justices, okay? But it's 5-9. You can't claim those 9 judges below or the 4 co-justices, you know, were acting in bad faith or anything like that. The next point, interesting point, is that you probably noticed the claim from my statement that, and Councilwoman Lindsay's as well, that this was all resolved in August of 2012. So in August of 2012, the plaintiff could build. And if they haven't built in August of 2014, there's 2 years their own behavior demonstrating by their behavior that they were not prepared to build for at least 2 years. And notice that the 2010 violation, alleged violation, was corrected in 2012. So if you had a 2010 violation and if it gave rise to monetary damages, if the school could prove that they were ready to build the minute they got it approved, then what happens with the fact that in 2012 they didn't build the minute they got it to be approved? What you might want to do logically is take the amount of delay between the approval in 2012 to now and work that back, because at least that much is not delay caused by the village. That's delay caused by, you know, whatever else. Of course, that's just a point of reference, a point of argument. Okay, I don't think we need to do the complaint. I do find it necessary, just for my own mental well-being, to quote one of their statements. Let me go to the next one. According to the Florida Rules of Civil Procedure, federals as well, a complaint is supposed to be a short, plain statement of the facts showing the pleader's entitled to relief. Actually, it's paraphrasing the actual rule there, right? And you go backwards, look at one of these allegations. This, by the way, is an exact quote. I didn't put sick in there, because the Latin phrase, but it is bolded, it is underlined, and it does have a capital E after the comma. The pleading is, simply put, enough is enough. Now, I taught civil procedure once. I'm not saying that the rest of that parts of the complaint aren't written in English, but in all honesty, that's really, you wouldn't pass Civil Procedure 101 with that kind of rhetoric in a complaint. It is true that just because you're paranoid doesn't mean somebody isn't out to get you, just because it's a silly complaint. 65% of the time doesn't mean you can't weed through it, go through the weeds, get rid of the rhetoric, and try to figure out what the actual claim is. And it's not Palmer Trinity writing it, it's their lawyers. Okay, what else do I say here? What's that say? Oh yeah, completed. This is the completed thing. It was all completed in 2012. They could have gone forward on 2012. They are properly applying for amendments now. The fact that there were disputes previously, and the fact that there was other litigation, as long as you're a public entity, you still have a duty to treat whatever application they have right now, on the merits right now. A private party could say, you sued me 10 times, I don't like you, I'm not going to do this 11th thing for you. But a public party can be sued 10 times over here if it's, that's not supposed to change the public entity's proper application of the law, on the current Palmer Trinity site plan. I think everybody knows that. But my point is that the site plan, just like the lights, are really not part of a settlement. I do know that the council looked at various elements of a proposed settlement and gave some advice to go forward and work in that direction. But the current Palmer Trinity site plan should be considered on the merits of it. What's good for the village and good for the school as a party, somebody in the village. And not to settle a lawsuit. The private party doesn't act illicitly when it tries to use litigation to get leverage. At least that's what I've always taught. However, the public party acts illicitly if it lets the private party succeed in using the litigation for leverage. I mean, this is a quite distinct thing, meaning a private party isn't illicit to try to talk a public entity into giving it more in response to a lawsuit than the public entity should give. That's just all of us. That's what the founding fathers said we all are. However, the public entity needs to separate them out. The monetary damages lawsuit you look at alone, the site plan you look at on the merits, give it to them, or do whatever you wish on that. And code changes to the entire ordinances of Palmetto Bay get looked at on the merits as well. The one that's pending or there's some reason to believe won't be pending. Well, anyway, I'll ask for questions. Thank you. Yes. How do we handle that? Do that for me, Megan, or Ms. Allen. Does it work?
Okay, I may be wrong, but I don't agree that this pending lawsuit and the zoning are independent of each other. It's obvious to me that Palmer Trinity does not expect to get any damages. These lawsuits, or some of them are extremely frivolous, that they don't expect to change the state and U.S. Constitution for this case. I think they're using this lawsuit as a way to extort more on the land use and zoning side from the village than what they currently have. And that explains why they haven't started building. Because once they start building on the approved plan, they commit to that plan. They want a lot more. And they're not going to drop this lawsuit, and they're not going to start building until they get a lot more. And that is the danger that we're facing here. They're using these lawsuits which they have no hope of ever winning to bully the village and the residents into getting a lot more on the building side.
Well, I may have misspoke or given them the wrong impression. What I intended to say is that as a legal matter, these lawsuits should be treated as lawsuits. And not only should you not, but you as a public entity really don't have a right to give substantive land use changes in response to a monetary lawsuit. It is true, however, that private parties often act that way with other private parties, and they often do it with governments, and rather than being surprised that it happens, I just find it appropriate to simply say their link of the lawsuits and the land use, though not illicit in their mind, is not something that this public entity will do, either with the people that represent it or with me as the village attorney. I mean, I don't control it, but I mean, that's, so I guess I'm saying they're practically linked and perhaps linked in their minds, but they're not linked here. That site plan will get reviewed on the merits, and the lighting will get, that ordinance change will get reviewed on the merits, or not reviewed if it's withdrawn, as it seems to be indicated it will be. And then the lawsuit, you need to decide how much, what you want to do with it, nuisance value for it and so forth like that. That's really when it comes to actually what to do, how much to pay them to go away on the lawsuit. That's really Mr. Hoffman. I think he once put a low nuisance value on it, but that was before, so it would only be fair to have him. As long as you're talking just about monetary damages, then you've got it separated over here, and you might want to buy him out for something. It's not improper. I'm told, I was not present, but I asked him one time, and I think he said he put $50,000 on it, but that's double hearsay. Was somebody here to hear that? I don't know. But you know, the point is, it wasn't millions. It was something because it costs, and by the way, the league can settle for a certain amount without your agreement. That's like most insurance policies, you know, if they think, well, you're going to win, but it's going to cost X amount paying Optum, so we'll just, they can do that without your agreement. You agreed in the insurance policy. They can settle as long as they pay. Yes.
There was a resolution passed by the village council authorizing a settlement. What's the effect of that resolution?
I believe the effect of that resolution is to, well, motion, yeah. Motion, 3-2.
Whatever you call it.
Something 3-2. I believe that this has been discussed. I believe the effect of that is that village staff, including the village attorney, are supposed to read it carefully and attempt to go forward with that when possible. To the extent that it referred to lights, I said lights are against the code and that cannot be done. That discussion, by the way, also acknowledged at that meeting that there was some issue with lights, but you know that it might be difficult. And secondly, I would say it's go forward as is appropriate under the law, and I don't believe that the site plan should be linked to a settlement as a matter of law. It is an indication, probably arithmetically, so to speak, that if there was something in that directed to staff that said something that would be changed in the development agreement, staff should probably prepare a proposal that would change that element in the development agreement because they got direct, but there is no legal effect of it. Oh, well, there's a legal effect because staff looks and says, well, 3 out of 5 have told us to go forward as best possible to do X, Y, Z, and if that took a change in the development agreement, they should probably bring it back to the council. But the council would vote brand new, all over again, from ground zero, as to what to do. The council is not bound by that 3-2 vote. But staff is probably under a good faith directive to do that to do that and bring it back to the council in a legal form so the council can act up or down on it. Now, the reason lights won't come back is because I, among others, and I'm not the key guy, but I mean many people, but probably the actual charter position of village attorney that says lights are against the code and would take a code change, that meant that the reference to lights there was not operative. They were not going to come back with a development agreement change that gave lights because we said lights were illegal, to use a point of phrase, or undocumented, to use another. Lights are undocumented facilities, undocumented aliens, illegal immigrants, undocumented immigrants, get the joke, undocumented facilities. So that went off the table. And other things there, they would be expected to come back to the council and say, you wanted this, this, and this, and here's the resolution, or here's the document that would do it, but they vote brand new over again. So it's got either a lot of significance if you count 3-2, or it's got no significance if you're asking legally. Does it mean anything? No, there is no settlement.
Was it an offer by the village to settle?
Well, there was a give and take, but the list that was used at the time was from a piece of paper written by Palmer Trinity's lawyer, but it was written after discussions and so forth. So who scribed the list from which they read may not be completely indicative, meaning it was like not totally theirs, kind of like, who wrote down the Constitution, I mean, Jefferson may not have written it. We say he wrote it, but it might have been somebody else in the room he was dictating to. But it was started as a proposal from Palmer Trinity.
If we had a quiet enjoyment law in the state, if we had more protection, because it seems like every time we go against them.
Well, that's a fair question, but it's a very, land use is a constant tension between the constitutional rights of the private property owner and the admitted constitutional rights of other private property owners who are interfered with by the crossover effects. There's not the lights are a perfect example. They're on one piece of private property, but they show and light up another piece of private property. So depending on what you mean by quiet enjoyment law, you almost always, sometimes one would, that phrase, kind of be careful what you wish for, because you may get your wish. What you really want is most of the policy decisions to be vested in a democratically elected government. Across the board, quiet enjoyment laws and things like that can come back to haunt you. You have to have, I don't mean to, I just mean this legally, I don't mean it as a social science thing, but just my experience in the legislature and elsewhere is that Oliver Wendell Holmes said it too, you cannot write a law that exactly covers everything in the future. You've got to put your faith in the democratic elections, or not just your faith, you've got to go out and elect the right people, so to speak, from your viewpoint. You can, I was asked whether you can put no lights in the charter, and I think you can. And you can put it in the charter with a phrase that says this is self-executing, which means it's not implemented by ordinance, that the charter itself is enforceable. That's not what the 10.2 does. It says do it by ordinance, but you can do no lights exactly the way 3110 does it in the charter and say this provision is self-executing, and it would be the law. But even that's changeable by a majority vote, so nothing is permanent. Majority vote of the electorate.
You may have just answered that. My question is that you were saying about the code. Now, the lighting as it stands, if before they said they weren't going to do it, I sort of don't believe that. I think that what may happen is that later they would vote to change the code if it's not put in the charter. Now, you just said that if the lighting is put in the charter, that we don't, we don't have this crazy lighting. And they can still change the charter then at a later date, or is that charter mandated forever?
A majority of the electorate can always change the charter.
What about the code? They can always change the code.
The majority, well, technically, well, strike the word technically. The ordinances are normally changed by a majority of the elected council. Your charter does have provisions that allow ordinances to be submitted to the electorate, or the electorate to challenge an ordinance and then take it to an election. Or the simpler thing is just amend the charter. But no document, including the U.S. Constitution, is enshrined forever. It may be difficult to change, but we put a federal income tax in there, which is the one I find amazing. I would vote for it, but I mean, when we often say the U.S. Constitution is impossible to amend, the fact is that after the Supreme Court struck down the income tax as unconstitutional, 3/4 of the state, 2/3 of the House, 2/3 of the Senate, and 3/4 of the states approved the federal income tax. So when you pay your federal income taxes, blame 3/4 of the states. So it is, everything's amendable. And perhaps this is too detailed, but the reason you're amendable by majority vote is because all municipalities, their charters are controlled by the Miami-Dade County Home Rule Charter, which says it's majority vote for a municipal charter.
And that would be in the city, not necessarily Dade County wide.
Well, yes, in the city.
Okay.
Palmetto Bay changes its charter in the city with 50%. The state legislature changed the state constitution to 60%, and that passed with 58%, interestingly enough. The amendment, 50 to 60, needed only 50, and it got 58, so it's there, so now you need 60.
Gary Pasquarello. I think we have some representatives that are presently looking down at their feet to see how big the holes are for having brought you on board. But first, would you, as a litigator, is this a case that you'd like to take to court? And secondly,
if I was the plaintiff for the defendant,
the defendant, you're being sued by Palmetto Trinity. Would you like to take him to court?
He's a defendant.
He is the defendant.
you need to make the decisions on what's good for the village. But how would I feel if the federal claims were dismissed and the state claims were there and I got to defend it? It would be really fun.
Another concern that I have, the vote that was taken recently that gave Palmetto Trinity both the zoning monies and the monies in settlement and included modifications to the site plan, that may now be null and void?
Well, that vote was not null and void at the time, but it was a vote, a sense of the council vote from my viewpoint, which is legitimate, discussed, and 3-2, and therefore staff, seeing that the majority wanted to go in a certain direction. To the extent that you can go in that direction in settling the lawsuit, staff was supposed to work on that, but it wasn't a done deal. It was not a settlement, it was just directions to staff to go forward. It was a good sign for Palmer Kennedy. He was telling staff more or less what to do. However, since staff has to act in a fashion consistent with the law, the lights got struck out of that like right away. And then site plan changes have to go through the quasi-judicial proceeding in which we have to assert both on the record and have to mean it in truly good faith. We are deciding it based on the evidence that's presented in the quasi-judicial proceeding. Even if it's presented by somebody we don't like, or it's presented by somebody we like, or anything else, it's supposed to be based on the hearing. So it's okay in a practical world to notice that certain people seem to favor certain changes to the development agreement. There's nothing illicit about that. But it then has to go through the proper proceeding. So later, having been done purely based on that site plan application and the law applicable to that site plan application, and without regard to prejudgment or the fact that if we give this site plan application, we're likely to escape some monetary damages. Nobody would say that, and you can understand why. It would not be an intention to sell public policy, but working through kind of Aristotelian logic, you would see that we gave a site plan change in order to save money. That's selling it, and nobody intended to do that and wanted to do that. And I think the village properly expects the village attorney to separate those things out, and that's how they're separated out. The lights are an ordinance, the site plan is a quasi-judicial proceeding, and the litigation, which is, a lot of money, is litigation.
Well, it seems there may be a quid pro quo on the part of the representatives, I don't know where or how, to put forward such, like the lighting and things such as that. So it just seems awful strange all of a sudden this lighting issue is something that has come up on the part of Tim Schaefer, where they now voluntarily realize they can't get it.
Well, here's the tension between the First Amendment and Robert's Rules, because the First Amendment clearly allowed people to articulate their beliefs about motives and so forth. Robert's Rules of Order says you're not supposed to question somebody's motives in a proceeding. But I'm just saying that's why the First Amendment repeals a bunch of Robert's Rules of Order.
By the way, speaking of articulation, if members of the public would wait till I come to them with a microphone so that you're on the record. Thank you.
Firstly, thank you very much for the free tutorial of constitutional law. I'm sure we're all learning a great deal. My question concerns the 3 lawsuits that Palmer has against us at the state level. If I understand correctly, Palmetto Bay enjoys sovereign immunity, and the only way they can collect a remedy from us would be if the legislature would provide them with that opportunity. And historically, that's been limited to tort claims of $100,000.
Right. Personal injury tort.
Yeah, so my question is could those 3 suits be considered frivolous? And if indeed they are frivolous, would that provide Palmetto Bay with a cause of action for those 3 suits? And also one other question concerning Florida civil procedure. I'm not familiar with it, but I don't believe an attorney has a right to file a frivolous lawsuit. And if we can get the courts to say this is frivolous, do we have a cause of action against their attorney?
Well, being personally the proud defendant in a number of frivolous lawsuits, one of which has been dismissed and is going to a hearing shortly about its frivolity, so to speak, or Rule 11 federal. In the state system, that's known as Florida Statute 57.105. And 57.105 is tough to get judges to enforce, actually. I just did a pitch to a judge about how if you don't enforce a rule, then according to Oliver Wendell Holmes, the rule is what the bad man gets away with. It's called the bad man theory of the law. That what people want to know is not what the rule book says, but what the sovereign or the courts are going to do. And if the courts don't do anything against frivolous lawsuits, then the rule is that frivolous lawsuits are allowed, despite the written rule that says they're not allowed. That's Oliver Wendell Holmes' path to the law about 1890. So, but it's very tough. And just like Palmetto Bay would claim that the fact that an appellate panel first upheld Palmetto Bay before another one reversed Palmetto Bay shows that Palmetto Bay did not act in bad faith, probably the average state judge is going to take those 3rd District Court of Appeals opinions and hopefully say the right thing, which is that doesn't violate due process, that doesn't prove any of that. However, it does have the language in there about Palmetto Bay having, these are just from the opinions, acted, without evidence. So the stuff that is normally said, but I doubt if a judge would, in light of those opinions, go in the other direction and say that the lawsuits were completely frivolous, although I think Hockman might think they are, and Hockman is your lawyer on these lawsuits, and I think it's 2 lawsuits only instead of 3.
It may give them pause for thought rather against launching these by.
Well, the next thing about 57-105 is that it's supposed to be paid half by the lawyer and half by the party, which is,
That sounds good to me.
anyway, I'll leave it at that. But it's hard to get. It's hard.
I just really appreciate hearing your point of view about the lawsuits, and I really wish that everybody in Palmetto Bay could hear this information. Is this being, it is obviously being recorded, is it going to be available? Yes, on the village website. I mean, it's just so important, and I can only presume, but please confirm that all of our village council members have heard exactly what you said, and this position, your position about the lawsuits. There is so much misinformation out there about the lawsuits, and I don't really feel that our council members necessarily fully understand what you have just said about the lawsuits. I also really appreciate your position and your point of view, which I think really needs to be out there in the community, that it's okay for the people to, you know, that's sort of their job to bring the lawsuits, but it is up to our council not to be intimidated by the lawsuits and not to bend their votes based on the lawsuits, because I think that's what's happening in this village, and it's very disturbing. I wish everybody in this room would write to neighbors, would talk to their neighbors, would get this information out there. This meeting is just really important. The information that's being heard here is really important, and I thank both you and Councilwoman Lindsay.
No, you have not overstayed. Stay right here. I just want to assure you, Mrs. Reed, that we have a gentleman in the back, our own Palmetto Bay resident, Hal Feldman, who is taping this for us, and I will let you know where you will be able to view the tape or to share that information with other people in the village so that they will be able to see this. Additionally, as I told you, the PowerPoint presentation that I'm in the middle of right now is available by clicking on my picture, and Mr. Leighton's presentation is also available by going to our village attorney's page on our website. Now, I know some of you have more questions for him, so I'm going to give the mic back to him.
Yes.
Good evening, Councilor. Thanks so much for being here. I'm going to follow up with the young lady's question there one more time. Have you had the opportunity to sit down with all the council members and explain face-to-face what you just told us tonight? I'm not sure if that question was ever answered. So.
It's been discussed and so forth. I mean, one of the reasons the report was written was to make sure that you know, even though I say they're not complicated, actually sentences can be complicated, and so that's why the report was written. And you know, all council people I've dealt with, which is all 5, have listened carefully.
Thank you.
Up front.
I wanted to follow up on the original concerns of Palmer County were the 30-year moratorium and the student population. At one time, the moratorium had to deal with the slow growth, where they would put, I believe, 40 students per year on until they reached their required number. And I was wondering, is that part of the settlement that
the Palmer Trinity appealed and successfully appealed the number and got 1150, and appealed the 30 years and got that eliminated. I don't recall exactly
go to the litigation page and look up the resolution from the 2012 hearing, which is Resolution 2012-64, you will see that part of that was a schedule for enrollment, and that is part of the 2012 resolution. And Mr. Lakeman, perhaps you could address the effect of the 2012 resolution on the proceedings that we're looking at coming up.
The 2012 resolution is the applicable regulatory structure for Palmer Trinity today. What the council chooses to do with respect to some things, I think most people know, there was I think the site plan has a 50-foot setback instead of 75 on some shrubbery and things like that. Although that's all going to be prevented. And we would, in the normal course of events, see whether or not any of the matters you're referring to are part of the application. But at the present time, our hope is that it's just a site plan and not significant changes to the development agreement. Unless, of course, that's what the council wants, and we just do what the council wants. But none of that is written in stone as to what they would get. And I guess the important thing is that June 11th? June 11th? No, there's a June 11th community meeting. Right, the meeting in which their application is to be discussed. That's an important meeting. Yes? Or, no, sorry, I thought he was holding his hand.
In the past, when there have been discussions regarding negotiations with Palmer Trinity, the subject of shade sessions has come up. Could you explain, perhaps to me and everyone else here, the ramifications of the shade sessions? Because it appears to me that everything that's done, we don't know anything about until it's finally resolved. Is that an accurate statement on my part? Is my understanding correct?
Well, the final action is not taken in the shade, but the state law, it's an exemption to the government and the sunshine provisions that says that a public entity discussing settlement or strategy of current litigation can meet behind closed doors. And the key one there is strategy, because settlement you can understand, talking about this much money, that much money, you don't want the other guy to know. Strategy is a broader term, so public entity can meet in the shade and keep the sessions. They have to announce it, they have to start the meeting in the open, indicate exactly what they're going to discuss, then go into a private or confidential session, have it transcribed, and release that when the litigation is complete. Now, you don't have to meet in the shade. There's no requirement that meetings be in the shade, it's just permitted. And there's no requirement that the transcripts be kept secret until it's over with. That's permitted. There can be good faith disputes about what is and is not the subject of the litigation, because frankly, different parties, a plaintiff and a defendant, will commonly have a different view about what that litigation is about, not just with a municipality, but what it's about. And the narrow view is that litigation is about civil rights and monetary damages. The broader view is that Palmer Trinity is asking for more in connection with the lawsuits so that more might be discussed in the shade. I'm not so fan of that, but I don't think it's automatically bad faith. It's just at the closer edge of it. Shade sessions, in my limited experience, usually cause more consternation about things that people thought happened in them than what actually happened in them, because they're usually pretty boring. I would recommend that a discussion of this lawsuit in the shade be a discussion about money. But the word, I don't want to drag this out, but it's possible for the transcript to show other words, because somebody might say, well, Palmer Trinity's asking for X. What about X? And then if there's a discussion where it's determined that X is not an appropriate remedy for the lawsuit, that was not an illicit discussion to discuss it. It's kind of like when a judge dismisses a case for lack of jurisdiction. The truth of the matter is that judge had a hearing on that case to determine that that judge lacked jurisdiction, right? So there's this interesting phrase that a court always has jurisdiction to determine that it does not have jurisdiction. So in a shade session, the mention of some other subject with a conclusion that that's not appropriate for the shade session doesn't violate anything, because you had to actually have that discussion before you could say, well, okay, let's not talk about that. You know, but the transcript would have that in it because you decided let's not talk about it. So I'm just pointing out that there should be no extensive discussion of it in a shade session, but there might be discussion of it saying, let's not discuss it. Therefore, it was kind of discussed. Yes.
Yeah, hi, how are you doing? First of all, I want to thank you for being here. It's been extremely educational. I had a couple questions. Number one is, since Palmer was able to build in 2012, does that mean that their site plan, and you don't have to excuse me, I don't know the correct terminology, their site plan is under the 2012 code, not the 2014 code?
The site plan that was approved in 2012 remains approved. If you change the code so that something that's in that site plan would not be approved now, it still remains approved in the site plan, vesting rights and so forth.
Okay. So, do you know what the difference between what they given a new site plan?
They've submitted a new site plan that's to be, well, I think it's revealed now. Essentially, you could go see it, but it's going to be conveniently discussed on June 11th.
Do you know what the issues on that site plan is compared to the 2012 code? Or any changes that they're seeking?
It is my understanding, well,
I heard there was a setback.
Mr. DeSalle and I have a scheduled kind of agreement that we're going to meet at some point and both agree that the site plan doesn't violate any code. You're not automatically entitled to it, but it doesn't take a code change. Meaning, for example, if the setback is required to be 15 feet, and the current site plan has 75, and they're seeking 50, they have to get a site plan approval, but if the code setback is 15, there's no code change needed. And it is a tentative belief that having removed lights, it's tentatively believed or hoped that the site plan involves no code changes. If it does involve a code change, it's just going to be whited out and told no.
So if it does not involve any code change, do they still have to go to a zoning meeting and get it approved by the council?
If it does not involve a code change, A, and B, it's considered minor or insignificant, that can be granted administratively. The planning and zoning department, I believe, I don't want to speak for them, but I mean, I talk to them a lot, is of the position, and then I would eventually be concurring with it, that they are changes that may be easily approved by the council or may not be, but that some of them are not appropriate for an administrative granting. That it needs to go to the policymakers.
1 second. So if there's only one, if it's only a setback issue, can the rest of the site plan be approved administratively and that one differential go in front of the council? Because they're not approving the whole thing because it's within the code of 2012.
That's like the 11th and 12th questions in the second chapter of the math book that are the
Sorry,
narrow
I'm
questions.
CPA, it's
You
just
get the
happens.
first 10 because they're just equations, and you can't get the 11 unless like how much water is behind the dam. That's a sophisticated question. I believe that if the site plan went before the council, I would have to check this, but the council could review the entire site plan.
Even though all within the site plan, 99% of it was within code and 1% was not.
Well, no, if the 100% has to be, all of it has to be within code. All of it has to be within code. It's just that if there was once a 75-foot setback and they want to go to a 50-foot setback and the code is 15, hypothetically, then they're clearly within code. They're like 3 1/3 times larger setback than the code, but they're smaller than their site plan. So that needs to be changed, and it's an administrative judgment that that is a significant enough change that it should be approved by the policymakers.
And who makes that judgment call?
That's the elected council.
No, I'm saying who makes the judgment call whether it can be administratively done?
That's initially done by the planning director. It would be, if considered in any way close, reviewed in a discussion with the village manager and the village attorney. And there'd be some consensus. The interesting point is, I believe it's not, you want administrative things done administratively to save time and council time and everything. But it can be a defect to do a significant change administratively. But I don't believe it's a defect to do an insignificant change through the quasi-judicial proceeding. In other words, anything you do quasi-judicially will be supportable with evidence. So.
Have a question? Mr. Lake? Sort of following up on the comment by Mr. Singer, I think a lot of the people in this room are, at least I am, sort of shaking in my boots, thinking that this decision might be made just administratively. Originally, I understand the original suggestion was a 75-foot buffer. Now the request has been reduced to 50. But it really isn't a 50-foot buffer because they have proposed to put a path in the middle that would be a running path and also a maintenance path. So now that 50-foot buffer becomes less than 25 feet between the property line. Now, maybe legally, that would be within the parameters of 15 feet, but it seems to fly in the sense of anybody's sense of decency and common sense that once if you agree to go from 75 to 50, and then you bifurcate the 50, so it's even less, you've basically given perhaps at most 20 foot. So to say, oh, but we agreed to a buffer, let's not kid ourselves. It's not a buffer if it's pierced by a maintenance path. So, I mean, it really makes me feel very uncomfortable to say, well, legally, they only need 15 feet. But it flies in the sense, again, of not negotiating this school in good faith with the people. Can you address that concern?
Well, that's really an issue on the merits that will go to the council. I don't know that anybody's made a decision on that, but I would, and I don't know if it's wise for me to say that as far as I know, that's going to go to the council. Well, actually, that's accurate. As far as I know, it's going to go to the council. The next question is, how much do you know? But that will definitely be considered and understood.
There was a petition, so you're saying it's up to the council. Could they be sued for saying, oh,
well, everything is like in the end up to the council, but it's not going to be issue, if certain council members believe a certain change should come to them for a quasi-judicial proceeding, and the staff believes it should go to them for a quasi-judicial proceeding, then there's no issue. I mean, who made that decision? That's just there's no issue because there's no struggle. It would only be a struggle if decisions were made not to take to the council on matters that one could argue was significant.
It's a very unpopular decision, so.
I'm sorry, I just didn't hear. The unpopular part I know about that. That's government. Since 17
No, unpopular to not require a whole, an unbifurcated or undisturbed buffer, so it truly is a buffer. And their proposal now is really, it's a joke, because it's not really a buffer of 50 feet. So,
well, you probably, it's not my place to say that, but whoever goes to the June 11th meeting probably wants to clarify that.
Legally, could they deny this if they're only required to have 15 feet?
Well, it's, that hearing is supposed to be based on substantial competent evidence. You proffer what you believe will be shown at the time, but depending on what else is shown at the time, I mean, it's not an evasive answer to say, yes, they can deny that, depending on what they hear in the hearing, or they can grant it depending on what they hear in the hearing. That depends on factual matters. I think what you said is clearly relevant to the hearing, that something goes on in between the 50 to the 0, that something else goes on. So as you're arguing, the setback is really different and so forth. I mean, all of that is relevant. Just difficult to say right now what one would conclude.
But it goes back to 2012, zoning.
What?
It goes back to 2012.
No, it goes to the zoning code today. They're applying today.
Mr. Singer, I have the mic.
They are applying today. I mean, they're applying today, so it's the code today. Actually, the code when they apply, which is today, in a month.
Mr. Lane, I thoroughly thank you for your presentation tonight. Very educational and very enlightening. Thank you. Following up on one of Mr. Singer's questions, let's say if, the only change was the site plan change from 75 to 50 foot, and if they took the running path out of it, it was a true buffer. That was the only change, that they go through an administrative change and not come back to a quasi-judicial hearing. Does that mean all of the other conditions built into the 2012 resolution would have to stay with no changes?
The last question first. The 2000 resolution stays in place except as explicitly changed. 75 to 50 is an explicit change, so that would be an explicit change. Everything else stays except as maybe explicitly changed, but I'm sure there's more than that.
Let me ask a follow-up question to that. There's a number of, call it, conditions built into the resolution involving traffic. I understand that Palmetto Trinity is not going to do a new traffic study. So the study they did with all the changes that were put in there with competent substantial evidence at the 2012 hearing and the hearings before that, all of those conditions have to stay on traffic unless they want to change the traffic, which would mean a whole new traffic plan, as I understand it, or a whole new traffic study.
It's been the village's position, the planning director's position, and my position, planning director is more important, that if any change is made that affects traffic, they would be opening themselves up to a new traffic study. If they make no changes that affect traffic, then they're not required to do a traffic. It's what you change.
Okay, so there's like 20 things on traffic built into that 2012 resolution. So they all stay. They can't. They were all put in there under competent substantial evidence, so those can't be changed. If they don't want to do a new traffic study.
But, I mean, they're not going to be changed. They can't be changed without a Yeah, can't is cannot is a odd word there, and I've testified as an expert witness many times, so I know kind of where you're going. But if there is a change, if there is any effort to change anything that relates to the traffic, they open themselves up to new traffic. So it is highly likely that all traffic restrictions will remain. It's not my place as a lawyer to say it, but I don't think they want to do another traffic study. So I think they're going to opt for all of the current restrictions staying right like they are, rather than getting tougher ones, which is probably what they might strike at, which is what they could open themselves to if they didn't another study.
Yes, if this lawsuit went to trial, how do you think? Do you feel that we would prevail and possibly collect attorney's fees?
Well, I can give you the answer that the more experienced people, at least like Hockman would give, which is, there's always this and we can't expect it. So the A, B, C, D, E, F, the qualifiers you expect, I don't think you would lose, as long as you allow me to fill in. The qualifiers you would get, like you don't know the particular judge, you might hear the case, you can make those qualifiers up. But Hockman is fairly confident about the village prevailing. Of course, there are a few things that we don't know about. Did somebody do an ex parte they didn't reveal? I don't think they did, but I don't know. It was a public record you had that you didn't give village. Hockman and I think no, but if we're Perry Mason and all of a sudden the witness pops up with something. But generally speaking, based on the complaint and what they know, Hockman is confident. He believes the chances of losing are small. And the chances of not being covered by sovereign immunity and therefore, or your policy, therefore facing significant damages is even smaller.
So as far as the current $800,000 opportunity settlement, that really then is excessive and pretty much off the table?
Yeah, that number is made up of a certain actual one and then credits for future applications, something to that effect, right? Less money and more future credits, which is like...
So we are no longer committed to that?
Well, you were never officially committed to it. The council voted to move in that direction, and it could move in that direction with money if it chose to. But it doesn't have to.
Marzena Schindler, I have just one question. Obviously, I'm not a lawyer. I need to ask a lot of questions. This one is a very simple one, because we see the Palmetto Trinity, in order to get to reach their goal, approaching us like a fox from different sides. Is there any limitation to what they are doing?
I think there's
no limitation.
Yeah, there's limitations, significant limitations.
Okay.
They got, they can build according to their current site plan. They have to ask for permission to change the site plan. Some of the requests may be reasonable. I mean, and are granted as a matter of policy. Changing the code is much harder to do. That's a discretionary legislative act. By the way, when we talk about quasi-judicial, it's not to sound fancy. It's just that the change of the code is a purely legislative act, which roughly speaking, setting aside racial discrimination and certain other motivation, roughly speaking, legislators can do what they want. Whereas the quasi-judicial, the site plan change, is supposed to be, according to the Florida Supreme Court, a decision based upon the application of law and evidence related to that law. So it's, the council is not free to simply say, if it was a legislative choice, I'd vote no. Instead, they're supposed to be judges and vote based on the evidence. That is a little difficult to figure out when you're talking about what's the evidence on 75 or 50 or what's the, but but such matters as were discussed, that evidence that shows that it may be within the setback, may be used for something else, so it's not a setback. I mean, but there have to be reasons. Legislators don't need reasons, as long as they're not acting on.
One more question about.
But judges do need reasons. Sorry.
One more question about the costs. When we are paying some money to them, and we have, of course, our insurance, what about our insurance premium?
That I don't know. Who pays the premium? I mean, the taxpayers, but who writes the check? Finance.
So thank you.
Finance. I don't know your premiums, and I don't know their. You mean like you have an auto accident and raise your rates? That's what you're talking about? Yeah. My USAA, they're better. Not better. Good. Thank you. Thank you. I'm sure that was too long.
I'd like to thank Mr. Lake and myself. I think he did an outstanding job, and I hope that you all have learned a lot. Now, there are a few other things on the agenda. I have a little bit more in the PowerPoint if you would like for me to go on. We can go through this quickly and then address any other questions that you have. Exactly. Okay, one of the topics that we had was on the settlement discussion, so I wanted to touch on that very briefly. In the summer of 2013, just to give you a last little portion of this, we had an all-day mediation meeting at Palmer Trinity with all parties involved in the lawsuits. I think all of us walked away from that meeting thinking that a lot of progress had been made. We didn't come to a final agreement, and any agreement that we did propose would have to go before the council, but there was progress. In July of 2013, Palmer Trinity submitted a settlement offer to the village council. On August 14th of 2013, the council sent a counter proposal. Now, let me go back to that date. Excuse me just a second here. August 14th, 2013, the council sent a counter proposal back to Palmer Trinity. That was decided in one of these shade sessions. On August 21st, negotiations halted. Palmer Trinity submitted a take it or leave it offer. That offer is on the village website. It is the settlement proposal that we're all talking about here today. On September 9th, the council had a public hearing and voted 3-2 to move towards settlement with Palmer Trinity. There was no resolution there. As Mr. Lehman said, we were just giving direction to staff to move that way. You can see that meeting, if you care to, by going to the video archive section. Does everybody know how to find it? Yes. Okay. And look for the September 9th council meeting. It's all there. The settlement offer that we're talking about includes removing all but 4 conditions that mitigated negative impacts on the residents. Those are contained in the 2012-64 resolution. Again, that resolution is on the village website under litigation. It included reducing the buffer from 75 to 50 feet. They asked for $200,000 in cash, and they asked for credits for building permits, inspections, and other fees totaling $600,000. They also requested lights on all the athletic fields. There are other things in that settlement proposal, and again, if you care to see them, they're on the website. As Mr. Lakeman has said, there will be a quasi-judicial public hearing before the village council, and the council will vote on Palmer Trinity's modified site plan. If you would like to be part of the presentation at Palmer Trinity, for review of that site plan. The meeting will be June 11th. I believe it's at 7 o'clock in the dining room, I believe. Again, that announcement for that meeting is on your village website. Before I go into anything on athletic fields, does anyone have any questions? Okay, very well. On the athletic field lighting, as Mr. Leighton has told you, our code does not allow them. They were not part of the resolution. So the athletic field lightings have never been approved. The lighting that was the actual part of the Palmer Trinity resolution that said that they could not have athletic field lighting, that wasn't appealed. There were only two things appealed, the 900 and the 30 years. No other condition in the 2012-64 resolution was appealed. And that is what they are under right now. Any questions? Okay, you all want to go home, I think. Okay, I'll go through this quickly. As for the ordinance 30-110 that we've been talking about, oh, I beg your pardon. Sorry. Yes.
As you all these dates and so forth, the code that prohibits the lighting on that area in residential, was that something that was modified and came with that after August 2012, or was that already on the books before?
Okay, and I want to address that, but I would like to call your attention to the handout I gave you when we started the meeting. We got one of those. Does anyone in here still have the navigating website? If you will look down at the very bottom where it says video public meetings, you will see under a regular council meeting on July 9th, 2012, starting at the time 15 minutes, 40 seconds, there is a long discussion with the council. I gave a complete reasoning for where all of this 30-110 came from. To answer your question specifically, that particular section of the code was written after the Palmer Trinity resolution. The Palmer Trinity resolution, remember, was finalized in August of 2012. That was written and finally approved. It was either October or November of 2012. So basically what happened there, and again, this is in this video, if you want to hear the whole thing, what happened there was that in 2007, this village with a different village council and a different planning and zoning director, and now, you know, it was a different attorney than we have now. So a whole different group of people examined a site plan for a school and came up with what they thought were good conditions to put on that development to mitigate the negative impacts on the community. Some of them are similar to what is in the Palmer Trinity resolution. Some of them are really written very poorly, and the one that always sticks in my mind is the one where it says that the amplified sound cannot be more than 40 decibels above ambient sound. Now, if you don't know what ambient sound is, that sounds like a really low decibel level because our code allows you to go up to 60 decibels. But it depends on what the ambient sound is there. So if the ambient sound is already at 40 and you're giving 40 above, then you're at 80. That one really stuck out to me. And there were others. And so what we did in this process of trying to come up with 30-110, we realized that we had zoning in our code for businesses. We realized we had zoning for all of our different residential parcels, regardless of the size. And we had zoning for apartments and townhomes and all of that. but we didn't have a complete section on non-residential public assembly uses in residential areas. And what was happening was, when these applications were coming forward, one was treated one way and had a different review process, or different people reviewing it is what I'm really trying to say. So they came up with some things. And then in 2010, when the Palmer Trinity resolution was first passed, the zoning director recommended certain things, and there wasn't any section of the code that applied. So what I thought would be a benefit to everyone, whether you were an applicant or a neighbor or a community member that wasn't directly affected, I thought, well, why don't we take the things out of the Palmer Trinity resolution that seemed to work in any situation, and why don't we put those into the code so that when something like this happens in the future, the applicant could go to the code and say, okay, well, this is what I have to do if I want to do a non-residential public assembly use in on a residentially zoned property. And I thought, and I still believe, we were simplifying the process and making it fair to everyone. As I think some of you may have heard me say in another meeting just this past on May 5th, you know, one of the problems was that people who were part of the neighborhood where the first development took place, and that was Westminster, if you're wondering, they had been told that they could have a 5-foot wall, or that was part of what the applicant had to do. But there was nothing in the development order that said when the wall had to be built. It was 5 years before the wall was built. Then I thought, okay, if we're really talking about protecting people, protecting neighbors from a big development, I thought, you know, it was reasonable to say, let's get the wall in first, let's ask them to plant the buffer, and things like that. These are not conditions that are meant to keep someone from coming into our village and building something that they have a right to build. And what I think the dialogue has, you know, turned into is one where people are saying, if you're interested in having a good relationship with someone next door and you ask for certain things, suddenly you're the bad guy. I think that we should come to the point where we all learn to respect each other's property rights. And I mean that at Westminster, and I mean that at Palmer Trinity. They have a right to build. Our code allows them to build. But you have a right to enjoy your home. And somewhere in the middle, we need to all agree that we're going to respect each other's rights along those lines. And I hope that we're getting there. One of the reasons I wanted to have this meeting is because I wanted you to know where we stood from a legal perspective, because so many people are out there telling you that you don't know. And I've long wanted to tell you, but as you can see, there's a lot to talk about, and most people really don't want to listen long enough to hear it all. So I commend all of you tremendously for sticking this out here tonight. But back to your question, Mr. Clifford, the condition about not allowing athletic field lighting came not just from the Palmer Trinity resolution, it's in the Westminster resolution too. I don't know that, and you can certainly look that up in the Muni Code Library, and probably not. But that's what happened at Westminster, and that's what happened with the council for the Palmer Trinity hearing. Those were two different councils. I wasn't a member of either of those, but I do think that we need to find a way to treat applicants fairly, and we need to have, I started with the wall issue, and then I think I got off, but Westminster had a 5-foot wall. Palmer Trinity had a 6-foot wall. The mayor at the time of the Westminster hearing sat up there and said, I don't like walls. you know, the people from the Westminster neighborhood came to me and they said, you know, it's been years since that resolution was passed and we still don't have a wall. There wasn't a deadline in there wasn't a date, there wasn't anything in the resolution that said when they had to build. So if the development order was good for 20 or 25 years, you know, technically they could wait 24 years to put the wall in. And I think, you know, what ultimately happened there was I sat down and several other people sat down with some of the people at Westminster and asked them if it would be possible to do a 6-foot wall. They were happy to do it. We had a public meeting. The neighbors were happy. They put the wall in. They put the landscaping in. The people over there, as far as I know, are very happy. But they didn't like it when one council put limitations on one private school and they didn't have the same protections, so to speak. So that's where part of this has come from, right out of the resolutions. I didn't make this stuff up, okay? I took what our staff had developed. They're the planners, they're the professional people. We rely on them. And that's where those things came from. And by the way, a lot of that 30-110 is in the county code too, right? And what our planning director did was to take different sections of the code and put it all in one place. And that helps you and it helps the applicant, because the applicant of a non-residential public assembly use in a residential area can go to that code and say, okay, I'm going to be allowed to do this, this, and this, and I'm not going to be allowed to do this. And he's going to know what other sections of the code apply. One of those sections has to do with construction dust. We're not talking about dust generated on the playing field. We're talking about dust generated by big construction. And one of the things we did when we put some of these ordinances together on neighborhood protection was we included a section in the code that specifies that you have to keep the dust down with water. We never said you can't build. We just said, let's show respect for the people that are living next door or downwind of this, and let's do what we can here within reason. I came upon that myself because, as the manager may remember, one day there was a tremendous dust cloud coming at me from one of my neighbors, and I was really not happy about the mess that was created at my house. There was so much stuff there. I could sweep it with a broom through my patio screen. It was particles of hay that they had spewed over the grass seed. Now, no one's telling them, don't do that, but maybe we could do it on a day when the wind wasn't quite so strong, or get the water out there just to, you know, keep some of this down. But this hay was spewing up into the air, and the wind took it and blew it right towards my side of their property, and my neighbor and I both got out the broom and swept it up. I still have the bag of particles. I didn't want that to happen to anybody else. It shouldn't happen to anybody else. I called the manager and he said, you know, we don't have anything we can do on this one. You know, our code isn't perfect. It will evolve as long as people live in Palmetto Bay. But when you see something that's missing that you need to live, you know, your life, you need to bring that forward and let us know what it is. And I think I've gotten way off your question. Yep. Okay. Very quickly then, on this proposed modification to 30-110, remember, you can go on the village website, on the home page, go down to Muni Code or Code of Ordinances, and you can type in the search box. It'll be SEC for section 30-110, and you can read it all there. The lighting matter was deferred from the May 5th meeting. It is on the agenda as far as I know for the June 2nd meeting, so if you're interested in that, mark your calendar and come back. The public workshop we have already talked about. If you go to the village website, you can find out more information about the workshop at Palmer Trinity on June 11th. And I'd like to give you an opportunity to ask any questions that you have, but I know some of you may want to leave, so before everyone slips out here, I just want to thank you all very, very, very much for coming out tonight. I hope you found this useful. Perhaps we need to do this far more often, and so that we can all be fully informed and that we can take ownership of our government. And I would be remiss if I didn't thank Mr. Hal Feldman, who has been videotaping in the back of the room. As always, Hal Feldman, who is a resident and realtor, has graciously donated his time so that you can be informed. And he is providing this entire town hall meeting for you on his personal website and also on YouTube. So if you're interested in that, you can see it there. Again, all of this information that you have seen on my PowerPoint can be found where? Oh, you have to do better than the village website. Where? Thank you, Sheila. Great job. Okay, on the village website homepage, click on my picture, go to the town hall meeting. This presentation will be there. Mr. Leighton's presentation will be on the village attorney's page. Yes?
And CCOCI will send it out and I'll have it on the link.
Great. Thank you very, very much. So that will be going out from CCOCI as well.
And,
yes?
The lighting has been part of Dade County restrictions since 19. The lighting has been part of Dade County's zoning code. Commercial lighting, residential since approximately 1970.
Mr. Pastorella, I'm not familiar with that particular section of the code, so perhaps you'd like to send it to me. I do know that right now we have it restricted. Remember, as you've heard often tonight, there are 5 people on your council. You always have to have 3 votes to get something through. So if you know that you want something, don't just talk to the person who's supporting you. It's important to go to the people who think, who may have a different point of view, and you need to persuade those people. Again, all of their contact information, my contact information is on our village website, and you can find that under council contact. The other thing that I want to make very clear before you leave is that we have a village charter. Again, that is on the village website. Under, anybody know? Under for sure, the village clerk. It is on her page. That charter is like your constitution, right? That's the big thing. And when people here are talking about getting something like the lighting issue in the charter, the reason why they want to do that is because you have control over that. You and every voter in the village has control over what's in the charter. So if you want to make it as an ordinance, which is where it is now, then a subsequent council can come along and change it. If you want to control it, you must put it in the charter. Now, some of these things look a little strange in the charter, but if it's the only way to protect yourself, that's where I'd go. There are 2 ways to get that particular issue in the charter. The easy way is to get 3 council people to say they'll vote for it. Now, I'm going to tell you right now, you've got my vote. And so now you just need 2 more. Oh, the mayor's raising her hand, so you've got 2 votes. So go out there if that's what you want to do and find a 3rd. In the event you cannot find a 3rd vote, there is another way. But it's going to mean collecting signatures. So it's a much more time-consuming process, but with all of you, you could do it. So talk to your representatives, talk to your council people, and get the job done that you want done. This is your government, and I'm so happy to see so many of you here tonight. You need to be involved, and I want to say one more time, you've got an election coming up. You need to go to the village website. It's under the clerk's page, Elections 2014. You need to see who's running. You need to look at what their campaign contributions are. You need to talk to these people and thoroughly vet them. They're going to be making the decisions that affect your lives. So don't take that lightly. Okay, I talked too much. Anybody else have a question?
Thank you.
Okay. Just 1 second. I would be remiss if I didn't give the mayor just a moment.
Well, it's great that everybody turned out tonight. It's really important, just as Joan said, all of the above, that I want to say thank you for coming. That's the most important part. You all know what's important. Look for the agenda coming up for June 2nd. There will be a charter amendment on there. Reach out to some of the folks that you need to approve that, to go through. It needs a 3-2 vote. And please come to the meeting on June 2nd to let your voice be heard. Thanks everyone for coming.